and gentlemen, I'd like to introduce to you Bill Marler.
Thank you very much. I'm very excited to be able to present, my condolences to your country for suffering through this horrible Listeria outbreak. I understand that over 107 people have passed away. That's very sad, and hopefully they can get to the bottom of this and prevent the next one. What I thought would be helpful is to let you know that we in the United States suffered through a similar outbreak in 2011, and I thought I would give you my perspective, not only from the legal side and the food safety side, but also from the patients themselves. So first off, I want to say, as a citizen of the United States and the world, I'm sorry, but we'll move on from this. The Listeria outbreak in 2011 in the United States was primarily focused in the state of Colorado. And ultimately it was found to be contaminated cantaloupe grown in Colorado and shipped all across the United States. And you can see from this slide the areas impacted and the number of ill in each of the states. For those who understand this nasty Listeria bug, it does sicken hundreds in the United States every year. It puts 99% of the people in the hospital. It is a very difficult bug to treat. The other thing that's always important is that the number of ill, even those that are counted, not necessarily the ones that pass away, are just really a tip of the iceberg of the number of people that actually are sickened. Most people with good immune systems might be sick for a few days or a week with diarrhea-like symptoms. But most of the time when people suffer a full-blown listeriosis, they're diagnosed by a blood test or a spinal fluid examination, and those people are usually the sickest. So that just really does represent a very small portion of the likely number of people who are sickened. In the outbreak that happened in 2011, 147 were infected with 4 outbreak-associated strains of Listeria. And you can see from the chart, sort of again, in chart form, what the prior slide showed by state. Very interesting facts are, the ages range from less than 1 to 96 years of age with a median age of 77. Again, that underscores the fact that it is generally immune compromised. So pregnant women, people who are on steroids, who have suffered from cancer, or the elderly. So you can see that the age population was skewed quite to the elderly portion. And again, 99% of those were hospitalized. There were 30 deaths reported, that ultimately wound up to be closer to 36, 37, because the Center for Disease Control and Prevention stopped counting deaths that were that came later. So somebody who developed Listeria was hospitalized and then was hospitalized for 6 months before they died. Those folks were not necessarily counted as part of the death toll. Again, pregnant women are one of the most vulnerable populations, and we represented in our litigation, one family whose daughter was born 3.5 months prematurely. This is a slide that sort of haunts me. A number of our clients sent us photographs of themselves or their family members that they lost. You see in the middle, Paul Schwarz, a number of our clients were World War II vets, some with Purple Hearts, some who had fought battles in World War II, and then to think that they come home, live a life, and then die from eating a contaminated cantaloupe, Listeria-tainted cantaloupe, was pretty amazing. Two of our clients were both military and died within a relatively short period of time with each other, and were buried in a military cemetery just feet apart from each other. So it was a real tragedy for a lot of families, a terrible tragedy. So every country has slightly different rules about how the law plays out. And I thought it'd be a good example to at least explain how civil liability dovetails with criminal liability and in food safety in the United States. So in the United States, there's a concept called strict liability, and it asks questions: are they a manufacturer? Was the product unsafe, and did the product cause injury? If the answer to each of those questions is yes, then the manufacturer of that food product can be held civilly liable for damages caused by their product. So in a strict sense, the cantaloupe grower processor was strictly liable under the law. They were a manufacturer, the product was unsafe because it had Listeria on it, and the product clearly caused injury. The idea of negligence asks a slightly different question of a different entity in the food chain, and that's the product seller. So the product seller might be a grocery store that sold the contaminated food product, in this instance, cantaloupe tainted with Listeria. And there, the question is to find liability on a retailer is, did they act reasonably? Did that retailer have knowledge or concern about where that product was grown, how it was processed? So the focus is on the retailer is, did they act with enough care to make sure that the product they were selling to a consumer was safe? It's a harder standard to prove against a retailer, to prove that they did or did not act reasonably. But ultimately, the retailer bears some level of responsibility for the product that it sells, even if they did not manufacture it, and even if they did not taint the product. The other idea to think about is punitive damages, which are damages to punish someone, and that's really focused on the knowledge. Did the person have knowledge that the product that they shipped was contaminated? And fortunately, that's a rarer phenomenon, but it does happen and has happened in the United States. There was a sort of infamous salmonella outbreak linked to contaminated peanuts and peanut butter called the Peanut Corporation of America, where they knowingly shipped contaminated product across the United States. Several hundred people were sickened and 9 people died. The president of that company is now spending the next 28 years in prison for that. And so criminal liability, very rare in the United States, and I'll speak specifically how in the cantaloupe case, there was criminal liability found on the farmers, producers of the cantaloupe. So again, this is from a court case, and it's sort of the definition of a manufacturer is quite broad in the United States. As you can see, it's a product seller who designs, produces, makes, fabricates, constructs, or remanufactures the relevant product or component part of a product before its sale to a user or consumer. So it's a very broad definition. It can be an entity that not only grew it, chopped it up, and put it in a plastic container and sold it, but it can also be a company that puts its label on it. So the consumer thinks that the product is actually made by the person putting the label on it, even if the person putting the label on it didn't really manufacture it in the way that we normally think a manufacturer works. A lot of times at the point when I'm talking to businesses in the US, it's like, my goodness, what can we do to prevent getting sued? And I said, the best way to prevent getting sued is to prevent the outbreak from happening anyways, that the best defense is preventing the outbreak. Because it really doesn't matter if the manufacturer took all reasonable precautions. So if a product is defective, if it has a pathogen in it, like Listeria or E. coli that poisons someone, the law presumes that the manufacturer did not, in fact, take all reasonable precautions. So ultimately, if a manufacturer produces a product that makes someone sick, they're going to pay, and wishful thinking does not help. So in the outbreak linked to cantaloupe in Colorado, there was a really interesting legal theory in the state of Colorado that allows for a retailer to be not found liable unless, because they're determined to be an innocent seller. And the idea behind this is that a grocery store, can't track everything that in fact is sold, and that to be aware of all possible defects in a product is too much of a burden to put on, multi-billion-dollar companies like Kroger and Walmart. And generally speaking, I think people can understand that that a retailer can't understand all that is going on in the supply chain. But there was a way around that, and the way we got around that was that when a product seller, like a retailer, is selling a product and the manufacturer and the supply chain goes bankrupt, the retailer steps into the shoes of the manufacturer as if they were in fact a manufacturer. So in the instance in this case, the retailer, and I'll talk a little bit more about this in a few slides later, the retailer ultimately had to be responsible for the manufacturer, because the manufacturer went bankrupt, the supply chain went bankrupt, and Walmart and Kroger in many respects were left holding the bag. But getting back to the outbreak itself, this environmental investigation slide, this is directly from the FDA's investigation. The interesting thing about the 147 people who were sickened is they all shared one of 4 genetic fingerprints of Listeria, and in interviews with themselves or their family members, there was evidence that within 30 days of becoming ill, they had consumed cantaloupe that ultimately was found to come from this manufacturer. In the United States, Listeria is a reportable disease. So once a hospital or a hospital lab knows that they have a positive blood or spinal fluid sample of Listeria, they're obligated to contact the state health department, which then launches an investigation to find out what the common denominator between the ill person and a food product they consumed. If they have multiple people, like in Colorado, if you remember the slide, there were 40. Colorado was being able to see 40 people and being able to try to look to see what the common denominator was between them. And then they were sharing that information throughout the United States through an entity at the CDC called PulseNet, which oversees the genetic fingerprinting of all of this. So they have, in a sense, an upstairs view of what's going on nationwide. But as you can see from this environmental swab test, they were able to find positive samples on a number of food contact surfaces for the cantaloupe. An interesting sort of tidbit in this outbreak was that the manufacturer also sold cantaloupes directly from the field at a farm stand on their property. There were no links to illnesses from the product that was sold directly from this farm stand. And the reason why that is that the cantaloupes that were sold directly from the farm stand did not pass through the processing line first. So it really was the processing of these, the cleaning of these cantaloupe to get the dirt and the mud off. It was the cleaning of that product that actually contaminated the product. So the FDA launched what was called a root cause investigation. So once they were able to link all of the ill people to the ill product and to this packing shed, they looked at how this could happen. The most important reason why federal agencies, public health agencies, do these root cause investigations or analysis is in part to see why the outbreak happened, but also to learn from those mistakes. And to the best of their ability, they were able to look at, Listeria as a sort of a low background level. Listeria is a common environmental pathogen that does wind up in any environment, but it grows really well in cool, wet environments. And that's where the product was, contaminated, was in the packing shed. The packing facility designed, water to pool on the floor, the washing equipment and drying equipment did not have a chlorine additive to it. So that was probably another reason why Listeria was able to grow in the brushes and the rollers where the product was cleaned. And with respect to growth, because like any bacterial product, it does have if it's growing, it makes the likelihood that people are going to get sick more often the case. And here, cantaloupes were not pre-cooled as they should have been. So it really allowed for, bacterial growth to a way that was definitely going to cause people to become ill. So some of the recommendations that the FDA suggested to cantaloupe growers moving forward, and many of those recommendations were actually codified into new regulations that came out post this outbreak. And the idea is, frankly, using packing equipment, designed to facilitate cleaning. It really needed to, sort of rethink that. They needed to validate and verify that the wetting and brushing operations had a chlorine-based solution in the water, and cooling and storing of the melons moving forward to try to cool them and store them in a way to limit bacterial growth. So ultimately, as I said earlier, there was blame enough to spread around. The Frontera, which is the broker, had visited Jensen Farm during the 2011 harvest and had suggested Primus to do an audit. Primus Labs, in fact, audited it through a subcontractor called Biofood Safety, which had given Jensen Farms a superior rating. And it was interesting that that audit was being performed as the product that caused this outbreak was being produced. Pepper Equipment had sold and installed equipment not designed for cantaloupe. In fact, had originally been designed to wash potatoes. So clearly wasn't designed to wash cantaloupe, and in part too because the water that was being used as a washing mechanism was not chlorine treated. It was just a perfect growth medium for Listeria. And the retailers, and I'll get more into why they were held responsible. But as you can see, these entities went many of these entities went bankrupt. The insurance proceeds and their assets were placed in the bankruptcy court, distributed to the victims, and we proceeded against Primus Labs and the retailers, primarily Kroger and Walmart, which they eventually settled. The litigation took about 2.5 years to complete. Earlier, I spoke about criminal indictments and used the example of the gentleman who's now spending 28 years in jail for knowingly selling contaminated product. In this instance, the Jensen brothers, they were also indicted criminally, but they were indicted as misdemeanors. So a misdemeanor conviction under the Federal Food, Drug, and Cosmetic Act does not require intent or even knowing or willful conduct. So under the Federal Food, Drug, and Cosmetic Act, a manufacturer of food that ships product across a state line, so in the interstate commerce, can be convicted if that person held a position of responsibility or authority in the firm such that the person could have prevented the violation. And what's interesting is that even with no knowledge and no intent, a misdemeanor provision can be held as $250,000 fine or 1 year in jail. The Jensen brothers, pictured here with their lawyer, pled guilty to 5 counts. So they were facing up to 5 years in jail and a $1.5 million fine each. The court gave them 2 years probation, no fine, no jail time. So I think, in somewhat ending this talk, and I think the most important thing from my perspective of what we have learned in the United States with respect to foodborne illness and prevention and Listeria prevention specifically are a number of things. One is how important medical treatment is for these people early, getting blood and serum samples, early, involving public health at an early stage to do the best that you can to try to see what the common denominator is between people, with the idea of being able to, get to that product as quickly as possible to get it off the shelf, if in fact it's still on the shelf, and to then try to work your way back upstream to figure out exactly how it happened and to prevent that next outbreak. Listeria, as I've said before, and as you guys have unfortunately been experiencing over the last several months, is a deadly bacteria. Given the long incubation period of 3 to 70 days, sometimes it's a big challenge to try to link it to a particular food product or a particular manufacturer. But definitely the technology exists, and that utilizing that information as promptly as possible is going to be the best likelihood of figuring these outbreaks out, stopping them soon, and figuring out how to prevent the next one from happening again.